Hello, everyone. My name is Ariella Wagner. I'm the founder of SunRay Construction Solutions, a national construction document service helping thousands of subcontractors and suppliers secure their lien and bond claim rights. Today, we have a spectacular webinar on the Tennessee lien law basics: who, what, and how much. The webinar is going to be conducted by Bryan Thomas. Bryan Thomas' practice focuses on construction and property related litigation, where he represents owners, EPC contractors, general contractors, subcontractors, and suppliers in issue and projects ranging from the state of the art power plants to residential homes. So, without further ado, I introduce Bryan Thomas.
Thank you. Wanted to welcome everyone first. The new software for all of us, but you can see the chat bar. If you've got any questions along the way, that should make it to me. And if it doesn't, Ariel will try to get my attention to make sure I answer them. The thought here is we are going to do a multi-part series on the Tennessee lien laws and try to give everyone a basics of what the structure looks like in Tennessee, understand it a little bit, understand some of the pitfalls and some of the things that you need to be aware of. What you're seeing on the screen right now is a list of sort of the basic, what I would call 101 level topics for the Tennessee lien law. And today we're going to start with the who, what, and how much. And as we go into that, I think it's important to recognize where liens started in the history. And it's pretty similar for most jurisdictions in the U.S. Tennessee is really no different. The concept of the lien law really started as Washington, D.C. was being built as a city, with Thomas Jefferson trying to find a way in which to convince people to go ahead and build structures and give them some security they were going to get paid. That concept developed over time and what is generally known as mechanics or materialmen's liens in various states. Tennessee recognizes it, like most states, as a lien being an extraordinary remedy, meaning that, hey, you've got your right to go sue and contract or collect on a contract. But the problem in a lot of times when you've got a defunct construction project is there's no money at the end of it. And so the lien right is an extraordinary lien right that comes under the statutes that allows you to collect against the property. And again, Tennessee is no different, but it's going to require what's generally and historically been considered strict performance, particularly with timing and notice. There was some amendments to the Tennessee lien law about 2007, went into effect in 2008, which added a section for substantial compliance. And we'll get into that a little bit later. It provides a little bit of saving grace for lieners, but it does not provide a ton in the sense that it still will not let you overcome a untimely lien. It will not let you overcome a failure to provide notice, but it will let you overcome, for instance, a typo in the address or something of that nature. So as we go into it, we go into the Tennessee lien law with that foundation. And we start with, okay, who has the rights to lien? And I say this, in a lot of states, there are limits. Pretty much all states allow a remote contractor to perfect a lien. That's true in Tennessee as well. And in Tennessee, you're going to see there be two sets of contractors or material suppliers. They're all going to be either a prime contractor, which would include a material supplier directly to the owner, and remote contractors, anyone at a lower tier. So even a sub to a sub under our lien law is still considered a remote contractor. And on a number of states, that's going to be limited as to who can bring a lien down the chain, a sub of a sub or a supplier of a sub. Tennessee does not have that. It's just primes and remotes. So no matter how far down the chain you are still a remote contractor and still have lien rights. The other thing to mention is laborers directly as individuals have some lien rights in Tennessee. And it's important to note that those lien rights actually have some extra priority. They're very rarely recognized, but they're there to protect the individual. The other thing that I will say here is there's a distinction in Tennessee law between commercial property and residential real property. And in Tennessee, while remote contractors have lien rights, they do not have lien rights on residential properties. Their lien rights are limited to commercial sites. There's a couple exceptions to that, and we'll get into that later in the seminar series. The other thing is, it's not just contractors, prime contractors, remote contractors, again, including suppliers, subcontractors. The Tennessee statutes also allow land surveyors, architects, and engineers to have some lien rights as well. Those have an interesting catch, two parts. One, for a designer, a land surveyor, architect, engineer to have lien rights, they need to have a contract with the owner or agent of the owner. And there's some case law as to whether a general contractor can be an agent of the owner. And the improvement actually needs to be made. So just doing drawings and things like that don't get an architect or an engineer lien rights. However, once those drawings are actually implemented, then those designers will have lien rights in Tennessee. So as far as who, just to recap, prime contractors have lien rights everywhere. Remote contractors have lien rights on commercial properties. Laborers have lien rights on commercial projects. Architects and engineers have it everywhere so long as the improvement is actually made and they have a contract with the owner. All right, so that's who. Now, what can be liened in Tennessee? I will say that the Tennessee statutes are not a picture of clarity in this respect, but they do provide a lot of guidance. And what I have on the screen for you as A, and you'll see in black, is the definition in the statutes, really where the lien statutes in Tennessee start. And it's all based on this word improvement. And it's also based on the lien securing the contract price. And I highlight both those two words because both are defined in the statutes to tell us what they mean. And as we go there, we'll start with contract and then go to improvement. A contract in Tennessee, you got your lien for your contract price, which presumes you have a contract. The definition of contract is an agreement for improving real property. And within that definition, it says written or unwritten, express or implied. And the reason I tell you this is when you say contract, people think, well, I don't have a piece of paper to show you. Well, in Tennessee, you don't have to have a piece of paper because an implied contract, even or oral contract, will get you lien rights so long as it is an agreement for improving real property. And there's some items we've got to get to as to whether you have an oral contract or implied in law contract. But if you can prove those elements, even if you don't have a piece of paper, you can still lien for the work. The contract price is also defined within the Tennessee statutes. And what you're going to see there is you're going to see, number one, it's going to be whatever the contract says. And it's going to say, hey, and even if you didn't put in there the contract price is going to be the reasonable value of what was given. And I will tell you the other important thing is it says and extras. And you'll see here a quote that tells you labor, material, services, equipment, machinery, overhead profit. And what I'm telling you is the Tennessee lien laws are pretty broad once you have a contract as to what actual work can be liened, so long as it is improving the property. And that takes us to our next slide. And this is a block quote of the definition of improvement. I'm not going to go through it word for word with you today. What I would suggest to you is the breadth of it. It includes a whole lot of things so long as you are improving the property. And later in the webinar series, we'll get into what's considered visible commencement, which has got some parallels here to what is an improvement. But for today, I just want you to know that you can lien so long as you are improving the property with the contract, with the owner. So that's what work can be claimed. I will even tell you that Tennessee lien law allows materials being delivered. It also allows specifically manufactured materials, even if they haven't yet been delivered, so long as they are ultimately delivered. And the best case of this is typically custom cabinets, things like that that are being custom built for a specific project or specific home, typically more on the project side because subcontractors don't have lien rights again on the residential properties. But it's again telling you how broad that depth of what can be liened. And again, as long as you're doing it to improve the property and it's delivered to the property, or in the case of a product that is being specifically manufactured and has no other reasonable value even before it's delivered, so long as it is ultimately delivered. Now, that moves us on to, okay, I've got the what, who can do it? I've got the what work constitutes it. Now, what property can be liened? And again, we're going to get into some of this in more details along the way of our seminar series over the next year. But I would tell you that it's the real property. And what do I mean by real property? I mean the land itself that the new structure sits on. So that's typically, in legal terms, we'll talk about it in fee simple or a couple other types of ownership estates. The other thing I would tell you is that the Tennessee lien law specifically addresses improvements for people that don't own the property. And this comes into play a whole lot more than most people realize. And what I'm talking about here is leaseholds and condo units, what in Tennessee would be considered a horizontal property regime. But think of leaseholds and condo units where you're asked to go in, and whether it's residential or commercial condo unit, go in and do an improvement for, say, a restaurant in a high rise that obviously doesn't own the high rise, but it's a restaurant that's got no funding. Do you have lien rights against that lease lessee? And the answer is this. The answer is you have a lien in Tennessee against the lease interest, but not necessarily the land in the situation I just gave you with a tower with a restaurant in the bottom. That said, and again, we'll get into it later, there are some exceptions that allow you to get to the fee simple. So what I would tell you is, number one, you got to pay attention to the person that you sign the contract with. Are they a lessee? Are they the owner? Is it a condo or is it a fee simple property? And you're only going to have lien rights as a general matter to the extent that the owner you contract with has lien rights or has property rights. Again, with the exceptions that we'll talk about later for being the agent of the owner. What I will also mention here is when we're talking about what property can be liened, the whole idea, going back to Thomas Jefferson again, is that you're improving the property. We're going to secure payment for that improvement to the property. You see that when we talked about the definition of improvement. So what Tennessee has done is taken that and filtered it down. And what I mean by that is Tennessee has statutory apportionment requirements. And that is whatever the lowest subdivision of the property, whether it's individual townhouse units, whether it's specific lots within a development, whatever the lowest division of those of the property is, you have to apportion your lien in the same way. There are some exceptions for that for lots that are next to each other that are all being improved as one lot. And there's a lot of details around this. I would just tell you, if you get into a situation where you've got really a new development, you see this a lot with site work, where the lots are being peeled off, or townhomes individually are being peeled off, or it's a new subdivision and multiple houses or driveways are being poured at once. I would suggest that you consult someone for how you apportion. I think the key there is likely to be an apportionment requirement, and it's possible that the courts will simply throw the lien out if you don't apportion. The practical implication of that is that you get a lien on more property than you could have ever obtained otherwise, because the lien, again, is limited to the contract price. Now, I think what we need to say is generally property, You can lien it in Tennessee. You can lien it to the extent of the interest of the person with whom you contracted. What you can't lien in Tennessee, it's pretty much the same as other states. You can't lien state or federal property. You probably heard of the Miller Act, the Little Miller Act, which requires the prime contractor, whether we're talking about federal work under the Miller Act or state work under the Little Miller Act, to post a bond. And so instead of lien rights, the contractor's security is within that payment bond posted by the general contractor. So again, no liens on state and federal property. The other thing in Tennessee that's a little bit unique is Tennessee allows private contractors to basically implement the public scheme. And what I mean by that is it allows a prime contractor on a private project to obtain and procure a payment bond and then record it in the chain of title. And so long as it does that, then a contractor, prime contractor, or remote contractor rights are limited to the payment bond, and there is no right to actually lien the property. Practically, that means either the prime contractor from an owner's bond or the remote contractor from a prime contractor's bond is protected on the payment side, and there's no need to allow an encumbrance to the property. Practically, we see this in a number of cases from prime contractors who, under a lot of times cost plus relationships with the owner, go ahead and get a payment bond and post it against the property so they don't have to worry about subcontractors' liens impacting the owner and the owner's financing. So I tell you all that, and I will tell you we've now hit the who, what work, and what property can be liened. I'm going to hit a couple limitations, and I know we're trying to keep these pretty short, so I'm going to go to just questions and answers. But what I would tell you as far as limitations at the very, very high level, know that interest, service charges, late fees, attorney's fees are expressly forbidden. If you lien those items, you have jeopardy of either the court throwing those items out or throwing out the lien altogether. You also open up some potential other liability for an exaggerated lien, which we'll hit in a further webinar. Now, the other thing I would tell you is furnishing tools, equipment, machinery. One rub when you're trying to put together a lien, particularly when you're using equipment that your own company owns, is what is the reasonable charge for that from a lien perspective. Some people want to throw in the purchase price. Some people want to come up with a rental value that is essentially the purchase price. There are some limitations within Tennessee law that I would suggest that we discuss. You see the definition up there of actual use in any reasonable period of non-use as some of the limitations that's in the statute itself. There are some cases surrounding all of this, but I'll just tell you to be aware when you're thinking about it. If you keep in mind that you're talking about a reasonable rental value, you will probably be okay. So that wraps up, I think, our first session or our first webinar, and I will look to see, are there any questions?
So far, you did such a sensational job that you answered all questions. But what will happen most likely is sometimes we'll have a few attendees. They'll have questions, and we're going to give you the attorney's contact details, which is on the next, I believe, slide. So in the event that you do have any questions, you could reach out to him directly and he can assist you. And I will let everyone know that I know that we went right into it, but Bryan is a extraordinary construction attorney who is very well read on the lien and bond claim laws in Tennessee. And he will be conducting, along with one of his associates, the webinar series. So can we maybe go on to the next slide and we could show them your contact details and go from there?
Sure.
I think that we have all those. So you could see Bryan's contact details below. Of course, if you have any questions or if you're nervous to ask a question, that always happens. Please don't worry, just send us an email and we will make sure that we answer all your questions. And Bryan, sensational webinar, very good. And we're looking forward to the next webinar with you, which our next webinar is going to be, when's our next webinar?
I think it's in 2 weeks, but I don't have that date right with me, Ariel.
That's okay. So we'll have everyone hopefully attend all these webinars, and by the end of the year, there'll be Lien and Bond Tennessee gurus.
Thank you all.
Thank you so much, and I wish everyone a sunny day.